started, I want to welcome a new member of the committee, Representative Mangiaputi. Thanks for joining us. I guess we're going to have some other new members, but they're not here today, and I'll let Carol take care of that when they're here. Okay, I'm going to open the public hearing on House Bill 274, and I call on the sponsor for this amendment, Representative McGuire, Carol McGuire. Can't hear is it on? There you go.
Wasn't firm enough. So yes, I'm Carol McGuire, representing Merrimack District 27, and I'm presenting Amendment 2293 to House Bill 274. When we heard this in the spring, there was quite a bit of opposition from various agencies that didn't think they should be included in the bill or exempted or included in rulemaking. I worked with the prime sponsor to review those agencies, and in most cases, their testimony was that they were not entirely state agencies. They were in a kind of limbo created so that they would comply with federal rules and laws rather than state rules and laws. And if they were subjected to the Administrative Rulemaking Act, they would be considered state agencies and therefore would not be eligible for the large quantities of federal money that they were distributing. So I couldn't see including them in this bill. We also included from the original House Bill 274 some clauses that were easy to implement. We put them in House Bill 357, I think it was. And so that included the requirement that every rulemaking register be sent to every member of the legislature. And also that when there were public comments on a rule, the agency had to report to GELCAR what those comments were and how they handled them. So what's left of 274 after deleting all those agencies are a couple of cases where the sponsor and I felt that we wanted to strengthen legislative oversight. So if you look at the amendment, part 1, when they're sending out notice of rulemaking, they have to send it to known stakeholders, which we hope will settle a common complaint that the professional organizations, if in the case of licensees, or known lobbyists or whatever, don't get the notice of rulemaking. And so that's something that we think should be fixed. And these days, when they're sending the notices out by email, it doesn't cost a whole lot more to send out 200 notices than 50. So that's there. And also, they will specifically send notice if it's a rule implementing new legislation, which is the time that the legislature most wants to be present, because that's the time when the first interpretation of legislative intent is made into the rule, and it's most important that it be congruent with the legislative intent envisioned by the legislature. So they'll send that out, and that's part 1. Part 2 is in the case where an agency is normally when they're either doing a major rewrite or implementing new legislation, they might go out for comment prior to having a draft of the rule. So they'll work with people on, what are the issues. And this one says that when they're doing this, they solicit comments. They also solicit comments from the Legislative Policy Committee. So if DES is writing a new water rule, or they're working on a major revision, they would deal with resources. If OPLC is deciding they're going to totally rewrite their investigative procedures, they might solicit our comment, that sort of thing. But again, this is only in the case where they're soliciting information. They just have to include the legislature. And the third one is, right now, if DELCAR makes a final objection to a rule for whatever appropriate reason it chooses, but doesn't vote to submit a joint resolution to be approved by the full legislature, the agency can implement the rule, except that they do not have the assumption that they are interpreting the legislature correctly. They have to prove that they are meeting the requirements of the legislature. This doesn't happen all that often, but it does happen. And so this goes on to say that if someone sues to say this rule does not meet legislative intent or it's got some other effect, the court can rule that the rule is invalid. And this amendment simply says that in that case, they'll pay the plaintiff's legal fees. So it's two rare cases piled on top of each other, but yeah, we thought it would discourage agencies from adopting rules that are usually very controversial, because that's the case where DELCAR can submit a final objection but not submit a petition. Thank you. So that was, these are the three changes that this amendment would make to the administrative rulemaking process, simply to get more legislative involvement early. And then if a rule is judged invalid, there's also a monetary penalty, namely they pay the plaintiff's legal fees. It completely replaces everything else that was in House Bill 274. And if there's any questions, I'll be glad to answer them.
Any questions from the committee? Yes? Sure.
Thank you, Mr. Chair. I see that the sponsors on this bill, some of whom are, shall we say, heavy hitters in the legislature, are they all on board with this amendment? Do you know?
I believe so. I've only spoken to a couple of them, and the sponsor is still working on the question of can a committee, or is it constitutional for a subcommittee of the legislature act in the place of the full legislature? But that is not included here. We'll see what the research shows. But she's happy with this.
Any other questions to committee? Representative Grotta?
Thank you. I'm in support of the amendment. I do think it's important that we work out how the legislative subcommittee on rulemaking interact with the committees themselves. And it might be that depending on who the committee is, there might be targeted approach for each of these legislative subcommittees and their committees based on rulemaking and their tendency to get involved.
Okay, but that's a matter of House rules, is how the subcommittees work. This would simply require notice, and from there, how it's implemented is up to us.
Representative Schmidt?
Thank you, Mr. Chairman. And Representative McGuire, thank you very much for your thoughtful amendment. My question will go to the aspect of workability because, as you know, the DELCAR meets at least once a month, year round, but the legislature is effectively kind of not participatory for about half the year. In the first year, and the second year is largely impacted by the upcoming election process. So how much the policy committee would be available is an issue. And
It is, yes, it is an issue. I am expecting that during the off-season, well, actually, even during the main season, we'll be lucky if you get one or two people on the committee to actually read the rules. This doesn't force the legislature to do anything. It merely gives them the opportunity to be involved. And I think we need to continue with the education to convince people that when you've got your bill passed, you're not done. If it requires rulemaking, you'd better get involved in the rules. So if the rule is created by new legislation, I would expect the sponsor and maybe somebody else to get involved.
follow up.
Follow up?
Thank you. There already is, as you know, a process by which stakeholders who would be impacted by these rules are invited to participate, encouraged to participate in the formation of the rules by the agency that will be charged with overseeing them, and that culminates in a public hearing after the agency has gotten its stuff together. Before that rule even goes to the JELCAR attorneys for their vetting of the rule, and then a public hearing as part of the JELCAR process. But is it your hope that by this informational process that you've been speaking to, that it will encourage more stakeholders to get informed, to get involved? Because the more they bring up issues of workability of a rule and so forth, the better we should wind up having a workable rule when it comes to time for the final
Yes.
product to come before JELCAR.
You're exactly right. By getting the stakeholders and the people in the legislature that are trying to change the law that the rule implements, getting them involved at the preliminary rule level or before is way more effective, and it's easier for the agency. All right, if they get the comments in from the sponsor of the bill that created the rule saying, this is pretty good, except this one section doesn't do what I thought it ought to do. You know, that's where I hope that the comments can be useful, is when they identify places where the agency has made an assumption that wasn't borne out, and it's within the scope of the law, so that the JELCAR attorneys will say, yep, that's legal, but you might have to deal with intent.
One more follow-up.
Follow-up.
Thank you, Mr. Chairman. So one of the aspects that is troubling to all of us who are involved in the process, as you and I are on the JELCAR, is this interaction when the attorneys bring us their work product. But one of the things that you referenced in your testimony was that final objections are quite rare. Do you have any information with regard to how often? I've been on the JELCAR now for about 17 years, and it seems to me like final objections are quite rare. Do you have any statistical information on that?
No, just that, like you, it doesn't. I remember 2 in 11. There's one about from the medical board, and they changed their rules eventually to clear it up. And then there was objection to the medical malpractice fund that was sustained.
Because the point that you raised is very valid, that the courts have already held that that if there's been a final objection and the agency has implemented the rule over the final objection of the jail car, that the state will not back up the agency. They're on their own to demonstrate that that rule in fact is constitutional and so
Right.
forth. So,
Right.
but
Yeah.
it would be interesting for me to know if we could get out of OPLC how often final, because
It's
of,
not from OPA, it'd
you-
be
you-
from, it would be from Legislative Services.
well, yeah,
Division.
that's correct.
I will try to have that information for
Right,
Thursday.
because as
Wednesday.
you stated, the joint resolution stops a rule that the jail car attorneys and the jail car just will not accept. But that does have to pass both bodies to become law. So
I will
that's
I will
pretty
see if I
pretty
can get that
uncommon
data.
as well, because the agencies usually do try to accommodate the jail car's objections and come up with a rule that the legislative side can approve. So,
Yeah.
but
The only
this I
time-
think can be helpful.
The only time I remember that a rule was implemented over a final objection without a joint resolution was the first Learn Everywhere rules where the majority of Jelcar voted to make a final resolution, but there weren't enough votes to submit a joint resolution. So those were implemented. It was a partisan issue, entirely unrelated to the content
It is
of the
uncommon.
rules. So that, I remember that happening, but there were very, very few other. I will try and find out.
Any other questions with the committee? Seeing none, is there anyone here anyone else who'd like to speak on this amendment to 274? Okay, seeing none, I'm going to close the hearing on the amendment to House Bill 274. And I think we've got about a 10-minute break before the next.
All right. Welcome back. I'm opening the hearing on Amendment 2349 to House Bill 518, and I call Representative Grota.
Thank you, Madam Chair. House Bill 518, which originally was establishing a commission to study revisions of occupational regulations of pharmacists and pharmacies, was retained by our committee with the thought that we would be using it as a vehicle for a non-germane amendment having to do with the modifications that were brought about in OPLC through House Bill 655. 655, as you may recall, was a rather large bill, and we took we took it in bite-sized pieces, and there were these small elements that were left behind that need to be changed in order to make the current statute harmonious with the changes that we made in House Bill 655. So that's where this amendment, 2349, would replace House Bill 518. And I don't know if you've had a chance to read it, but it does talk about how the license fee collection, how licenses will be reinstated. Where this used to be done by the board, this is all being done by OPLC now, and RSA 310 is going to be the RSA that all of these legislative components will be found. I think there are people here from OPLC who could answer any further questions. I believe there is one word that needs to be changed, which I missed, and I apologize. And I think, there you are. Thanks. It's on page 2, and it's page line 26, where it says holders of lapsed licenses. That should actually be expired licenses. So that sentence makes more sense because we do say earlier that lapse licenses, expired licenses shall not be able to renew, all right? So that's the only change that we think needs to be done, correct? Yeah, are there any questions? Always a lot of questions when it comes to these kinds of bills.
Thank you, Madam Chair. On what the representative brought up on line 26 on page 2, I can accept that. But I just wonder what would be the flavor of this committee, because where we needed to draft another amendment, Madam Chair, on this, and can we give it sort of like the green light if that's the only change that is to be made? Because it seems like an awful lot of work went into this.
Yes, we should. We're meeting again on Wednesday to vote on this. Today is the hearing. So we should debate whether this is what we intend. And if so, can we get another amendment that fixes it? But for now, she's saying her intent is that it's for expired licenses, which is,
Well, it
clear
makes,
enough.
if you read the sentence before, it says expired licenses shall lapse for 1 year from expiration and holders of expired licenses. So it's a continuation of that. But I'm sure we can get it redrafted.
Okay. And so to clarify, the intent is that for 1 year after their license expires, they may apply for a renewal.
Correct.
If it's been more than a year, they've got to take some extra steps.
Correct.
Okay, thank you. Representative Dolan.
Yes, thank you, Madam Chair. As one committee member, I would indeed support that edit going forward.
Thank you.
Okay. Representative Mangiaputi.
Thank you, Madam Chair. I said I was not going to make a comment, but having had a profession where I had to get licensed for 35 plus years, it was that 1 year gap. I mean, 1 year grace period is very helpful because you get the renewal the previous year, December. If you miss it, you forget about it. Used to be 2 year renewal window. And so that really helps. If it wasn't for that 1 year, I would have a harder time.
Okay, thank
Okay.
you.
Any other questions, comments? Thank you very much. All right, I think time to bring up OPLC and the
Yep.
heavy guns. Mr. Osterhaus and Director Courtney. Yes, Representative Schmidt.
Thank you, Madam Chair. Looking at page 2, uh, line 8 is a kind of a linguistic tangle here. I think there's something grammatically wrong or a word missing, or maybe I'm not able to read it at my advanced age. Licensee possessing a license in good standing may, if to the best of the licensee's knowledge, is, what's the subject of is?
He or she, the licensee in question.
Licensee,
I think what you're saying is there should be a comma after knowledge.
No, you need a noun, a noun there, or a pronoun. The licensee possessing may, if the best of their knowledge, they are not.
that phrasing makes some sense. This doesn't work very well, or it's going to be hard for people to really know what it means.
Yes. Okay.
So that needs
Yeah.
to be reworked, I think.
Thank you. The intent of that was to clarify that if the office has gone through the bother of collecting, of evaluating your application and then denying it, that's not refundable.
I get that part, but
Okay. All right. Yes, grammatically, it looks like they need a they or something in there.
yeah.
All right. Any other questions for Representative Broda? All right. Thank you very much.
Okay, thank you.
Good morning, Madam Chair, members of the committee. I am Lindsay Courtney, Executive Director, OPLC. With me is OPLC General Counsel Douglas Osterhout. So thank you for the opportunity to speak on behalf of the amendment to HB 518, which is essentially just further cleanup of OPLC's codification efforts last session. The first part of this is really intended to clarify when licenses expire versus when they're able to reinstate. I will say historically, some boards had been able to do a late renewal as opposed to a late reinstatement. And this meant that after their license expired, they were permitted to renew their license up to a certain period of time. The challenge with that is that the license issuance would backdate to their original period of licensure, which misrepresented a period of potential unlicensed practice. So last year, the statute was changed to make it clear that licenses expire at their expiration date and may be subject to reinstatement. But with the clarification between the terms lapse and expire, the intent is to make clear how long a licensee can reinstate. And that obviously is a policy decision up to you. What's represented here is a period of reinstatement for a year, which is pretty typical, but obviously that's something for you to consider. The other thing that this bill does is it defines good standing, which is a term that we used last year in HB 594, but it was not defined in statute, so I thought we should probably define that in statute. The other major change that this bill proposes to accomplish is to make clear that our presiding officers can and should assist the boards with presiding over non-disciplinary adjudicative proceedings. So last session, we were able to obtain legislation that directed our presiding officers, who are lawyers, to preside over disciplinary proceedings. But there are hearings that we have for which are not disciplinary in nature. There are licensing proceedings and then non-disciplinary remedial proceedings. And I would like to say that the process is going very well. And so I think that it makes sense to further require our presiding officers to assist the boards in that regard. And there's no real policy reason why I think we would want to distinguish between those two types of proceedings. So this proposed amendment would make that change as well. And then finally, I think on page 5, and this is there, the same change is made throughout the bill in a couple of different places, but we have run into circumstances in which a board cannot meet quorum and has not been able to meet quorum. And the question becomes, what are our legal remedies when there is no board? For example, the Board of Registration of Medical Technicians has not met in, I believe, 2 years. We have a number of complaints, 2 of which were considered emergencies, and there's nothing the agency or the state can do other than to try to fill the board position. So this would allow a situation in those rare circumstances for the agency to act if the board is not, if there is no board. And then I said final, but I will say final again. On page 7, last year, in a couple of different practice acts, what we call charging language for discipline was repealed, with the idea that the original version of HB2 655 and then 409 included some charging language. It didn't end up being included in the final version, and so we think that there needs to be some general charging language for what could constitute misconduct for all professions, and then the board still retain the authority to further clarify that in rules or rely on their own practice acts. But there should at least be some general charging language, and that's included on page 7. Is there anything else?
Yes. Okay.
I'm happy to answer any questions you
Certainly,
may have.
Representative Shuda has a question.
Yes, I think another tweak on page 5, line 18, direct that evidence be received solely. I think that should be by a presiding officer, not be.
Oh, yeah.
Line is actually just above
18.
Yeah. Yeah, should be received solely by a presiding officer.
Mm-hmm. That's the problem with having several pages of legalese. Representative Blackus?
Sorry. So I'm noticing on line 18, it's received solely, and if we make that change solely, by a presiding officer, and below the next line, the authority given to the presiding officer. So is it the, does it matter? It looks like those should be the same, so whichever way. I mean, it just looks odd. Probably the meaning is fine.
It should probably be the.
Yeah.
All right. Any other questions? Representative Schmidt?
Thank you, Madam Chair. So you referenced earlier in your, excuse me, in your testimony, Madam Director, that situations where it's remedial but not disciplinary. So that strikes me as kind of a gray area. Is that well defined? It may be that something is not being done right, but it's not illegal or awful or what destructive or whatever. In which case, I mean, but the question is, How did it happen? Just ineffective practice? Is that well defined? in your-
Yes, it's defined in our statute, and it essentially is intended to encompass the circumstances in which typically happens if somebody starts to experience cognitive deficiencies and may not be fit to practice, but it's not necessarily, I mean, you could bring a disciplinary action, but you don't necessarily want to, because the issue is not did they commit misconduct? The issue is at some point we have to reevaluate their current fitness to practice. So that those are usually the circumstances, and they're few and far between.
Okay. All right. Any other questions?
Thank you for your time.
Okay. Mr. Thompson?
Good morning, Madam Chair, members of the committee. My name is Simon Thompson. I am a contract lobbyist with Sheehan Finney Capital Group. Here today on behalf of one of your favorite members of the public, Steve Rancour from ECBA, the Electrical Contractor Business Association. He could not make it today to provide some feedback and asked that I do. Many of the items, or a couple of the items that I was going to bring up, I think have been addressed, but I'm going to just restate them just so we're all on the same page. Representative Fellows, you caught one of the typos on page 5, line 18. You change B to buy. I think that also needs to happen on page 6, line 16. Same thing. I think it must have probably just been a cut and paste.
Yes, indeed. Thank you for catching that.
So going back to page 1 in the issue of reinstatement and versus renewal after your license expires. So how it is set up is that your license expires today, tomorrow, a week from today, you could pay a late fee and get your license renewed. We just want to make sure that with this new language, that if my license expires and a couple of days later, a couple of weeks later, we get our license reinstated, that we're not paying a renewal fee and a reinstatement fee. As it's set up right now, we renew our license, and if we're late, we pay $50. We just want to make sure that it's not a reinstatement fee and a renewal fee. I did consult with Director Courtney prior to this meeting, and she said that it's not, but I just wanted to make sure that that is brought up and that we can get some confirmation on that. Additionally, in that section, starting on line 27, page 1, we would request the potential of a 60-day grace period. Prior to, for many, 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 many years, your license renewed on your birthday, kind of like when you need to get your car inspected. That's something, I don't really think about getting my car inspected. Oh, it's October. It's my birthday month. I got to get it inspected. So now it's just a date. And with all that's going on, licensees sometimes just forget that date, and they've asked for or are requesting kind of a grace period. I'm throwing out 60 days. Could be less, could be more. That's up to you.
Okay.
And I think you could put.
I believe, Mr. Thompson, that when we went over this, the license doesn't, the lapse occurs 1 year after the expiration date. So
Right.
there should be no problem whatsoever within a day or a month. And if
Right.
that's not clear enough, perhaps we should consider tweaking the language, because I think that's the intent, that
Okay.
we definitely don't want to penalize someone, if they mail in their license and it gets lost in the mail and they have to try again a week later.
Yes.
Representative Broda, you have an answer.
Well, I have a comment. I don't think so what we don't want to have happen is someone doesn't renew, because everyone's responsible for getting their license renewed at a particular time, because they all know when their license is going to expire. What we don't want is someone to realize that they haven't renewed their license, and then it's reinstated, and then it's backdated to the time that it should have been, because that they didn't have a license then. So I think that's one of the things we have to consider when we discuss this. The intent is not for that to happen. Right?
Right. So I think the only kind of go back to my car inspection analogy is that you do have 10 days after your birthday month to get your car inspected, and you can still drive it legally. So we're just trying to make sure that there is times where you do forget your renewal date, and so we were just asking for some grace period there. But I do also understand the portion of not having a license during that 30 to 60 day period. So I don't know, I don't have a fixed rate this second, but I just was asked to convey that there should be some grace period.
Okay, well, it appears that there is a 1-year grace period to be able to reinstate the
Reinstate.
license without
Losing it.
penalty. But it doesn't start, you don't cover it doesn't cover the period of time where you hadn't renewed.
Okay.
And I believe this is the sort of fine print that is normally covered
In rules.
broken out in the rule, so I hope you will read it. Representative Leck has a
Thank you.
question.
I'm just trying to clarify my understanding of the process, and maybe somebody from OPLC will end up answering. But so if you don't get it renewed by the expiration, then you're operating without a license for some period of time, which is illegal, I guess. And so the
cases.
question is, yeah, you can get it reinstated by paying the extra $50, but is somebody going to be prosecuted for operating without a license during that period? And I don't see anything that says you wouldn't be,
No, it's not.
or is that rules?
So I can explain Representative Lakes how it works right now, which is if somebody files an application for reinstatement, one of the questions is have you practiced without a license? And if they answer yes, we still proceed with reinstatement because they've met the minimum qualifications to have the license, but it gets referred over to enforcement for potential inquiry into whether or not there should be discipline. Usually when that happens and the Board of Nursing has this set forth in rules, they go through disciplinary process and they're issued either after a settlement agreement or hearing an administrative fine for practicing without a license. But if you just let your license expire, you took 3 months off and then decided to reinstate and you didn't practice, there wouldn't be that disciplinary process. The boards used to hold up somebody's reinstatement if somebody answered, yes, I practice without a license, and use it to consider whether or not they should issue the license. But from our perspective, that should never be really a factor because the person has met minimum competency.
Okay, thank you.
Yes, all right, thank you.
And thank you for that. And I guess my last, I didn't get to ask Lindsay about Director Courtney about this, but on page 3, line 10, I'll start above. It says the docket file for each such proceeding shall be retained in accordance with the retention policy established by OPLC. And I just didn't know if it would be prudent to either cite where that retention policy is. Or
That
what?
would be a good idea, except that the OPLC and the Secretary of State are working out exactly who would be responsible for that. The archivist has given the OPLC some guidelines, which they are using and enforcing, but it's not really their rule, it's somebody else's rule.
Okay.
At the moment, this should get you to it.
Okay. That is all I had. So
Well, thank you very much.
thank you.
Representative Gould, though, might have a question.
Thank you, Madam Chair. I'm not sure who this question goes to, but I wanted to make sure I was understanding. If a licensee forgets to get their renewal in on time, and then they get their application in to renew, they have a fee for reinstatement, is there also a penalty? Were there two fees? I got confused a little bit there. Thank you.
Thank you, Representative Gould. So there is a fee to get your license, which is if you're renewing, it's the renewal fee. If you're reinstating, it's the reinstatement fee. If you're getting your initial license, it's the initial license application fee. The only time a fine comes into play is whether you've practiced without a license, because that is misconduct and is considered discipline.
Thank you.
Any other, Representative Schmidt?
Thank you, Madam Chair. So I wonder whether we need to give some more thought to this idea of practicing without a license because your license is expired and you forgot about it or whatever. But so much of our lives are governed by what the insurance companies will cover or not. And if you're outside of that insurance coverage and there's a problem, a doctor makes a mistake, has an accident or whatever, and they're in that gray area where the license has technically expired, or it's discovered afterwards, oh, he or she was practicing for maybe a couple of months without the license and then something happened. I wonder if we need to kind of try and think through this, maybe not to solve this particular bill's language at the moment, but whether we need to think it through a little bit more and
Yes.
come up with a better situation. I mean, for example, my birthday is on May 29th. Okay. So that means when May comes around, bing, I know I have to get my license and my registration, my vehicle registration renewed. And I know you have 10 days to get the car inspected after the registration period, but the registration period, the next day, if I'm driving on June 1st and I haven't re-registered my vehicle, I'm driving an illegal vehicle if I'm stopped or if I have an accident and so forth. In my case, as I say, I'm aware that I have an obligation to re-register my vehicle, but somehow it's not really till the 29th of the month when my birthday is that it starts flashing red.
Yes, thank
And
you.
I've only got a couple of days before the end of the month. So it's, but the insurance aspect, as I say, I just wonder whether we could give some more thought to something about, is there an additional period where the license is, I don't know.
Director Courtney, if someone submits a renewal application, you know, the day of the expiration and and it takes a couple of days for processing, is that considered practicing without a license?
No. So, and we are required to notify licensees, and we do notify licensees 60 days prior to their expiration date that they have to renew. But under 541A 29A, I believe it is, as long as they submit it prior to the expiration, and it could be 11:59 p.m., it will remain active in our system as designated active renewal until we process the application. So they won't be practicing without a license.
Okay, so that as long as they've gotten the application in by the end of before the expiration date, they're good.
Yes, and
However inconvenient it is for the office.
right, and as long as they can demonstrate an intent or an attempt to renew, we treat that as coming under 541A 29A. So if, you know, they say that the system was not working or the payment processing, as long as they demonstrate an attempt, we count that as well.
Okay, thank you, that's reassuring. Representative Lanjaputi.
Thank you. This is online filing, you could do it if the system is down or something. But if you mail it by snail mail, it gets lost. So to have a proof, is that something that would be considered of that it was with intention of doing it before the expiration? Like you can say stamped, but if the mail is lost,
So I believe our current rules require that for paper applications that it be received by the expiration date, or that is something that we could consider changing. Although I will say that we're gladly moving away from, as a matter of routine, have our license applications processed via paper. So that it may become a non-issue, but that's something that we can certainly consider.
Okay. Representative Blackus?
Thank you. So the discussion of the motor vehicle registration brought up a question. That is, in motor vehicle registration, you can actually handle that the month before your month of your birthday, which is what I usually do. So how early can someone start the renewal process before the expiration?
60 days, Representative.
All right, thank you.
Okay. Which is when they are reminded. Okay. All right. Other questions? All right. In that case, I will close the hearing. I will mention to the committee that we are meeting to vote on this on Wednesday. So I'll see you all then.
Somebody going to clean up the language within the
Representative Broad, are you taking care of these little? Thank you very much.